So let's begin with Eleonora Rosati, who will kick us off with the first part.
All right, thank you so much, Daphne, and good morning, everyone. It is a pleasure to be here today. In the time at my disposal, I would like indeed to offer some remarks regarding the basic requirements for copyright protection and the rights granted by copyright, which could help set the scene for the subsequent presentations by indeed Kacper. Specifically, in the time at my disposal, I would like to touch upon 4 points. The first one is what copyright is and why it does exist. Second, when copyright protection does arise, what rights it does grant, and how, generally speaking, one can comply with indeed the legal restrictions posed by copyright. So without further ado, let's start with the first question. What is copyright and why does it exist? On a lay level, you could say that copyright is the legal shape of creativity, and that is linked to the fact that what copyright law does protect is indeed objects of creativity, whether it is music, whether it is books, art, and so on. But the truth of the matter is that copyright is also fundamentally an instrument of technological governance. And since its very inception, it has been concerned with addressing technologies that would allow the making of copies of protected works. Indeed, modern copyright laws were born in response to the invention of the printing press, which made it easier and cheaper to make copies of books. And therefore, the question of how to control the making and circulation of these copies became legally pressing. And since then, it is what the copyright law has been consistently concerned with. The image that you see on the slide is a photograph of author Oscar Wilde, which was at the center of an important US Supreme Court decision in the late 1800s, in which the very question was whether photographs could be protected by copyright. And this, in a way, is a discussion that echoes what you might have come across in terms of protectability, for example, of AI-assisted outputs. So, why does copyright exist? I think that what I've just said, in a way, gives the response to this question. There are some countries in which there is a stronger emphasis on the personal connection between an author and their work, and so they emphasize this natural entitlement. And then there are countries in which the view of copyright as a legal incentive is indeed at the basis of why this right does exist. We all benefit from the objects protected by copyright, and indeed the authors of these objects need to be incentivized by receiving legal protection for a certain period of time. Having said that, the information that you find on the right-hand side of the slide that indeed are retrieved from Gemini is fairly accurate. So copyright is not a single right, it is a bundle of rights. And indeed, as I shall be explaining in a moment, they belong to two main groups, moral rights and economic rights. The former relate to safeguarding the personal connection between an author and their work, and the latter are more relevant to the economic exploitation of a work. An important thing for you to be aware of is that copyright arises automatically. You don't need to register anything. There are countries in which indeed the registration is done also for historical reasons and for reasons of extent of protection. One such example is the United States. But unlike other IP rights, copyright does arise automatically. And the duration is, as a minimum, the life of the author and 50 years after their death. In Europe and in the US, this duration is set at life plus 70. So, on a practical level, copyright is a free right. It applies to any kind of work that satisfies the relevant requirements for protection, which I shall detail in a minute. But the downside is that you may not really know if you have a valid copyright until you try to enforce it. The following slide does summarize what I've just said. Let's now move on to the requirements for copyright protection. In essence, no matter where you are based, there are three key requirements that need to be satisfied. First, there must be a work. So, in essence, what copyright does protect is the expression of an idea and not the idea as such. So, I am protected for the way I tell the story of two teenage lovers coming from enemy families, which might remind some of you of Shakespeare's Romeo and Juliet. But I don't have a monopoly over the idea of writing about teenage lovers coming from enemy families. What copyright does protect is the expression of ideas rather than ideas as such. Second requirement is that there must be an author, someone who has created the work. Third requirement, this work must be sufficiently original. I will break down a bit more in detail both the notion of author and the notion of originality. But I would like to alert you that in some countries you might have additional requirements. And also there might be types of works, for example, works of applied art or designs, which historically have been more difficult than other types of works to receive protection under copyright law. But let's leave these aside for the moment and let's focus instead on the notion of author and the notion of originality. First of all, author. Who is that? It is a notion that, legally speaking, is not really defined, but we can say on a substantial level that the author is the person in charge of the creative process. The law does not require the author to be also the material maker of the work. What is needed is this creative control. And this dispute that you see on the slide, which was decided in France, I think gives you a good idea of what I mean. You may be familiar with contemporary artist Maurizio Cattelan. He has realized many artworks, including the one that you see at the center of the slide, called La Nona Ora. And the interesting thing about him, as it is the case of many other artists, is that he doesn't really materially make all his works. He avails himself of some crafts people who indeed work under his direction. And one of them, Monsieur Drouet, who you see portrayed on the right hand side, did materially realize this artwork that I've just spoken about. And he believed that it should be regarded in a legal sense as the author of the work. But in the end, a French court sided with Cattelan and found that Cattelan and not Drouet was the one in charge of the creative process. So, in a nutshell, if you only execute someone else's tasks, as it was the case of Drouet, without having any creative input yourself, you will not, legally speaking, be regarded as an author. And that is something that applies also in the context of artificial intelligence. Increasingly, AI is being used in a generative fashion to produce text, images, videos, etc. And you may ask yourself whether you own, on a legal level, these outputs that you generate. The response, here you have the one provided in the US, but I would say that it also applies in a European perspective, is that you will own the parts of the output over which you have exercised your creative control. Bottom line, if you use AI and you still maintain creative control, you can still legally own this work. But if the creative control has not been exercised and something is purely generated by artificial intelligence without any input on your side, then you will not have any legal rights over the resulting output. Now, if we move on to the second requirement, a work is only protected under copyright law if it is original. Now, this is a term that indeed lends its side to ambiguous interpretations, also because even on a lay level, we find it difficult to identify what originality does mean. Having said that, and being mindful that this is an area that is still very much contentious, I would say that as a benchmark to qualify as original, a work needs to be the result of free and creative choices. Both requirements need to be present. So freedom without creativity is not enough. You need to exercise both free and creative choices. And indeed, the mere effort that one might put in creating a work is not enough. This effort needs to be free and creative. Now, as I said, this is a contentious area. There is a case law that is still being issued on this matter, but of what I've just said, for the time being, it seems to be good law. So as a result, if you see an image like the one that you have on the slide, in which there has been the mere digitization of a painting that is no longer protected by copyright, because as you remember, copyright lasts for a limited period of time, then the effort made into creating this digital reproduction is not free and creative. And it is unlikely that the statement made by the museum that there is a new copyright in the digitized image could be regarded as indeed correct on a legal level. So having clarified at what conditions copyright protection does arise, let's now focus a bit more on the rights that it grants. As I mentioned, they belong to two main groups, moral and economic rights. And as far as Europe is concerned, moral rights remain regulated on a national level. So you can have, legally speaking, very different situations across the various EU member states. Economic rights and related exceptions, that is, activities that you can perform without having to obtain the right holder's authorization, are instead harmonized. Yes, on a legal level, there are still some differences between national realities, but broadly speaking, this is an area in which you have much more uniformity than what is the case for moral rights. So let's zoom in a bit more into these matters. As I said, moral rights do preserve the personal connection between an author and their work. And since they are personal rights of the author, they are usually non-transferable, meaning that the author cannot get rid of them. So if you write a work in the course of your employment, you may not own the economic rights to your work, but in principle, you will still be owning your moral rights. You may be incapable of exercising them though, because in your employment contract you might have agreed to waive your moral rights against your employer. So this is something that is routinely done as part of employment contracts. And I would like also to inform you that if you work in countries like the UK or Ireland, then on a legislative level, it is already provided that moral rights are not available to authors who are employees in relation to works created in the course of employment. So, having said that, what are the moral rights that are available? They vary from country to country, but on a minimum general level, you would have the right of attribution, that is the right to claim that you are the author of a work, and the right of integrity, that is the right to object to a distortion, mutilation, or alteration of your work that is prejudicial to your honor or reputation. A classic example, the turning of a novel into a pornographic film production, is a classic example of a potential breach of the moral right of integrity. And just to let you see how things might be different from country to country, I would like to indeed mention this famous French case in which the director of the film Asphalt Jungle was able to enforce its moral right of integrity over the unauthorized colorization of this film that he had realized starring Marilyn Monroe. So this is a situation in which probably the director would have not been legally successful in countries like the US, where he was indeed based, the UK and other common law jurisdictions, as we call them. But in France, he was able to enforce his rights, given the strong stance that this country, like other continental European systems, does have towards the protection of moral rights. Coming to economic rights, these relate, as I said, to the possibility to exploit on an economic level indeed a work. And these rights have been harmonized. So if you consult a lawyer in Germany, they will tell you about the German right of reproduction. But if you then consult a lawyer in Portugal about the Portuguese right of reproduction, you will probably get the same answer. The reason being that these rights have been harmonized at the European Union level. And by means of a, if you wish, necessary simplification, the main rights granted on an economic level include the following. First, the right to make copies of a work, that is known as the right of reproduction. The right to sell copies of these works, so that is the right of distribution. The right to rent or lend a work. Example, if a library allows you to take out a book, that is because the library has cleared this right that I've just mentioned with the relevant book publisher. Then there is the right to perform or show work in public. So if you go to the theater to watch a play, indeed it would have been necessary to obtain the authorization of the holder of the rights to the play for this public performance. Same thing with the right of communication to the public. If you have a streaming platform that makes available a TV series for you to watch, the streaming platform will have obtained the permission of the relevant copyright owner to indeed make available to its subscribers this content. Then there is the right to make an adaptation, turning, for example, a novel into a movie. It is something that requires authorization. So these rights that I've just presented can be owned by the author of the work, but can be also owned by someone else. The reason is that copyright is indeed a right under property, so it is possible, as I will be mentioning in a moment, to indeed transfer your copyright to someone else. And of course, the basic rule is that to perform something that falls within the scope of copyright protection, you will require permission from the copyright owner. Nevertheless, that is not always the case, as Kacper will also explain, because indeed there are also exceptions to copyright. That is, indeed, provisions that allow one to use a work without the need for permission. So generally speaking, if you want to quote from a book, you can reproduce a short extract. If you want to make a parody of a film, you may be allowed to do so without the need for permission. If you want to criticize a book that you have recently read, by indeed reproducing some extracts that you don't approve of, you can do it under a relevant exception. The reason why exceptions do exist is because the law does recognize that copyright needs to be fairly balanced with other rights equally deserving of protection, including freedom of expression. Just for your information, depending on the country where you will need to consider relevant copyright laws, you might have rather different approaches to exceptions, and the main distinction worldwide is between countries like those in Europe that have a closed catalogue of exceptions, so a list of activities that are allowed, and countries like the US that do not have such a list. What they have instead is an open-ended doctrine known as fair use. And in essence, what you need to do is to consider a series of factors that will help you indeed decide whether you need permission or not. The final point that I want to address is indeed how it is possible to comply with copyright laws. As I mentioned, the ownership of copyright can belong to the author, but can also belong to someone else. So the general rule is that the author is also the first legal owner of the copyright. But that is not always the case. So if you create a work as part of your employment, it will be most likely your employer and not you who owns the relevant copyright. There are also similar approaches in countries like the UK and Ireland, where this is provided by law as opposed to an employment contract. And then you have doctrines like in the US known as work for hire, in which in essence the person that might be also a company who commissions the making of a work is deemed to be the author and therefore also the copyright owner. So, how to comply with copyright law, bearing in mind that it has become quite a broad right in scope and it covers many activities. There are in essence two ways. Either you have permission from the copyright owner or you are able to enjoy an exception. Permission is obtained through a contract, a license, a transfer. There are different ways in which this permission can be tailored. I will mention just the two main instruments, licenses and transfers. If you get a license, you get the permission to undertake a certain activity. For example, a license to reproduce someone's article. If you instead get a transfer or assignment, it's not merely a permission, it is a transfer of the ownership in the copyright of the work. So you become the owner of this legal right. And then there is the topic of exceptions, which Kacper will detail to a greater extent. And these activities, as I mentioned, do not require the permission of the copyright owner, but you need to double check that the relevant requirements are fulfilled and indeed also assess the scope of the exception and therefore the legal protection that you will be enjoying in this situation. And with that, I conclude my presentation, and if there are any questions or comments, I will be more than glad to take them. Thanks a lot.
Thank you, Eleonora. Thank you very much for your valuable perspectives. If there is any question at this point, yes, please. You can take the floor. Buha Mohnani. Yes, please. You can unmute.
Okay. Thank you, Eleonora, for explaining this so well. I have a question about AI taking the whatever the picture or artifact asset generated by AI. So if I'm prompting the AI to generate something, how do you see that? Would that come? I mean, can I claim my copyright over it or no?
So the right answer in copyright law is always it depends. And it is true also here. So I would say that you may be owning the rights to your prompt. If the prompt is sufficiently detailed, for example, you may be owning already a first copyright there. Then looking at the output, it depends on indeed the level of involvement that you have had in the creation of this image. So if you have subsequently refined the prompt and indeed looked for getting a different output from the one that you initially obtained, so you guided the result to get where you wanted, then it might be possible to imagine that you own some legal rights over this image. But if your involvement is minimal or very basic, it might be more difficult to claim this successfully.
Okay, thank you.
You're welcome.
Okay, if there is no other question, we can continue with our second expert, Kacper Szkalej. Kacper, the floor is yours.
All right, thank you so much. I'll share my presentation here. Okay, so you should be seeing my
yes, we can see your screen.
My slides, great. Very well, thank you so much, and thank you so much for having me over. I'm, as already stated, Kacper Szkalej from the Institute of Information Law at the University of Amsterdam. During my presentation, I would like to sort of go into an aspect that is probably quite fundamental for the research sector, namely copyright exceptions, and a couple of other things related to licensing as well as open access. And well, really the aim is to untangle a little bit of the complexity. Copyright has this capacity, as Eleonora showed, the rights are very broad. It has the capacity to influence everything, what materials you're allowed to use or read, whether you can store them, how you share your findings or collaborate across borders. You could basically say that it's the invisible force shaping your academic life, a little bit like gravity, but with lawsuits. So the presentation that I have, I thought I could divide it into three parts. And first, discuss some general principles that apply to the copyright exceptions or fair use, if one wishes to call it that way. So these are common. And then zoom into the more concrete provisions and a couple of licensing aspects and challenges, and generally the basics of how this framework works in practice. And then finally, end with a couple of insights on open access and reusing your own research data. This has also some copyright implications in practice. But before I start, I think it's good to just understand where researchers are in the copyright system. They do occupy a special position, one could say, because they're connected to often public institutions whose job is to create knowledge or advance society and innovation forward. And the copyright system, essentially like any other intellectual property rights, recognizes that this is essential for society. So this is not any kind of user, but one that actually also contributes to a better advancement of society as such. Researchers do wear many hats, one can say. I think most essentially in practical terms, they use or reuse content that is protected. So from a copyright perspective, they are users of copyright protected content, which means that, well, even if they are unaware of this, they're not lawyers, they must navigate between copyright exceptions on the one hand and copyright licenses on the other hand. There's different types of licenses, either that are entered into directly by the researcher, such as when you want to access a particular article through a service and you pay for access, or they can be negotiated by institutions directly. A number of countries have what's known as collective licensing arrangements or extended collective licensing arrangements. These are normally entered into by the institution and sort of concern bulk users, often with collective rights management organizations, as they're referred to. And the copyright system tries to some extent at least, balance these different mechanisms. How that is done is quite critical. Too much reliance on licensing may limit access and mission-driven activity. Exceptions, on the other hand, might be too narrow or subject to legal uncertainty, and licenses can simply complement the use that is permitted. Secondly, researchers are, of course, also creators in the copyright system. You produce a lot of data, the science or the knowledge. The use of that, both how you approach it and what others can do with it, is also something that copyright may affect. I will get back to this towards the end of my presentation, as the essential part for today is really the first part, how to access and what you can do with it. So there are a number of principles that are important to remember, I guess, throughout my presentation that sort of qualify what copyright exceptions are. I put a small subtitle here, European Fair Use. As Eleonora has indicated, this is a term that many may have also heard, mostly in the US. The European approach is slightly different. But the essential thing is to remember that copyright exceptions are not loopholes. They are designed deliberately to mediate between different interests, for example, to promote research and education, to realize academic freedom, and so on, especially in the academic sector. So for that reason, they are part of the system together with the exclusive rights. Eleonora mentioned that the catalog, at least in the European context, is exhaustive, which means that there's a finite amount of copyright exceptions that say more or less exactly what you are allowed to do without permission. And that's the main difference with the American fair use provision, where the catalog is not, so to say, closed. That has been criticized in legal scholarship, which I will not go into further today, but it essentially means that one needs to look for the concrete provision that allows certain use. In the legal debate, there has been, well, what we see, including the work of courts, is that there's a changing landscape into how copyright exceptions are approached. The courts have, a number of times, changed the way they look at the provisions, without wanting to be too legalistic here, but essentially trying to look beyond the textual, the text of a provision, and looking at the actual purpose that an exception tries to achieve. In two cases, the European Court has also qualified copyright exceptions as user rights. And perhaps this is a more of an academic or theoretical qualification, but one could say that this is well, shifts the balance into how users, including researchers and institutions, should approach the role in the copyright system. That means simply that copyright exceptions become as important as the exclusive rights that exist. So this is a general overview. A very important principle in the European copyright system is the so-called three-step test that is codified in Article 5.5 of what's known as the InfoSoc Directive, our main instrument. And this provision provides that exceptions and limitations shall only be applied in certain special cases, which do not conflict with a normal exploitation of the work and do not unreasonably prejudice the legitimate interest of the right holder. This principle or rule has been approached by the European member states in slightly different ways. Legal theory also theorizes how to view this provision. Is it an umbrella provision that is sort of layered onto any copyright exception, or is it instead part of it as an interpretative rule, for example, that may have the potential of further narrowing down the scope, etc. Nevertheless, the rule does exist, and it cannot be ignored as such when talking about copyright exceptions and evaluating them. But at the end of the day, it does depend on the situation or the member state in question. I'll get back to this point in a second. Apart from the three-step test, another important principle to bear in mind is the principle of territoriality. Even if there's a lot of harmonization going on of copyright exceptions, well, the rights as well, but copyright exceptions, the scope is still national. That means that there's a catalog of exceptions in every EU member state, and that means there may be variations because national law still matters in this context. Most of the framework is based on what's known as directives, which are a form of legal instrument adopted by the EU that allows member states or requires of member states to reach the objective, but they may determine how they are going to reach that objective. So whenever we see a provision in a European directive, let's say InfoSoc Directive, or some of you may have heard what's colloquially known as the Copyright Directive, there may still be minor differences in how member states have transposed that into their national legislation. Another aspect here is that quite a significant portion of the exceptions framework is optional in character, which means that member states may also opt whether to introduce it or to not introduce it. There are provisions that I will also mention that are mandatory in character, in the sense that they have to be introduced in every member state, which does provide some assurance from the perspective of cross-border users, naturally. And a separate sort of question is, are they mandatory in contractual relations? Often when there are interactions with right holders where there's a need to obtain a license, one of the biggest questions that we legal researchers deal with is, well, should a or is a copyright exception mandatory in the sense that it cannot be contracted out? As we shall see, this also varies and depends on the exception, and it also has further practical questions. So with these principles in mind, let's turn to more concrete aspects. The two questions that are essential here are, first, where do you get your material from? And secondly, once you have it or have access to it, what are you allowed to do with it? And the exceptions try to answer, well, mainly the second question, but not only. Think in terms of copying. Copying is a big word in copyright. Actually, it's called reproduction, the exclusive right, as Eleonora presented, but it really does cover really a lot of uses, including storage or passive storage. Sharing material activates a different right, but also quite essential in the context of research. So in terms of where do you get your material from? Depending on the type of content that you try to access, or this, it will activate a series of sort of questions, or it affects what you can do with it, whether it's copying, sharing, or reusing the work. So the public domain status of a work often implies that the copyright has expired to the content. So that essentially means that one is free to do whatever one wishes with the content. There are also special licenses designed for persons that wish to make their content available and offer it to the public domain, for example. But essentially, the public domain implies the public domain status that copyright expired and is free to use. As Eleonora mentioned, the main rule is 70 years after the death of the author, which is still very long. But also the main point is that there is a limit to it. So there is a possibility to determine that status. Secondly, access can be based on licenses, as I implied before, which can be direct in the sense of contracting directly with the right holder, or they can be institutional in the sense that the institution handles the licensing part, which can also be direct or collective, etc. In the latter case, often researchers are not always aware of the exact conditions. This is handled via the library. Often it's incorporated into library search systems like a library catalog and so on. However, and this is also what Eleonora implied, licenses come in all shapes and sizes. If the rights are exclusive, they are exclusive. Right holders have the possibility to determine what sort of uses can be made, both in terms of geographical scope or in terms of duration or the amount of users that may access or reuse in a particular way, or the format of using, such as being able to use from specific terminals or a client in the computer network of the institution, the amount of users that may connect at the same time, etc. So each right holder essentially often tries to set their own terms for what can and cannot be done. And the degree to which that is specified also depends, right? So a right holder may decide to prevent uses, for example, or to explicitly say what is allowed, or refrain from preventing, letting instead copyright exceptions govern the actual use. So in this context, we often speak about closed licensing or proprietary licensing and open licensing. If you work with software, you may have heard the term FOSS, which is free and open source software. The software industry was very quick with approaching this from the perspective of letting many resources be available under open licensing. But in more broader terms, and considering the academic sector with all these different disciplines, some of the familiar categories of licenses that we can see originate from Creative Commons or Creative Commons licenses. And these are often used in so-called transformative agreements where open access is realized, or when creators want to release it on favorable terms. We see these icons or indications, BYNCSA. Essentially, that means that credit needs to be provided, but use is quite broad, or that use is quite broad on condition that it's not commercial use, or that there is a share-alike, so SA share-alike requirement, that use is very broad on condition that the user of the material, whatever they create, will also make it available on the same terms. This is known as a copyleft license. So the idea is that, well, use is provided on predictable terms through a license, is very broad, but may include certain conditions relating to whether you have to attribute appropriately or certain further uses that you can make use it. And this is, of course, the most traditional way of obtaining material directly from the right holders, or because something has lapsed, copyright protection has lapsed, it's free to use. But knowledge institutions themselves are also a great resource for material. We don't often think of them as such, but knowledge institutions or libraries or cultural heritage institutions, while they also negotiate licenses with right holders, as I indicated, they're also users in a copyright sense. And the copyright system introduces a number of copyright exceptions specifically made for them to ensure that they can realize their various missions, right? So, for example, libraries can make certain copies of works, that's in Article 5.2 C of the InfoSoc directive, or they can make available, which is a digitized way of ensuring that patrons of a library can, or an institution can, access content from the terminals on the premises. For example, if they have digitized material, they may in certain ways use and so make available orphan works, which from their own collections, which are types of copyright protected content for which the author is unknown. They may preserve cultural heritage that is part of their collections, for example, by digitizing it to preserve it. If it's in a analog format, for example. They may also use out-of-commerce works from their own collections. These are the types of copyright protected material that, as the name implies, is out of commerce. So, for example, a book that is no longer available through normal means of commerce, like a bookstore. And these also provide an excellent source of material because it sort of comes from within the copyright system. Copyright recognizes that these knowledge institutions are essential for maintaining knowledge, but also for preserving it and making it accessible, and therefore they also need to be able to do that, and that often is steered on the basis of copyright exceptions. Now, turning to researchers as users and the second question. So what are you allowed to do? As I mentioned, licenses come in different shapes and sizes, so a license may already offer very broad uses, completely skipping the need for a copyright exception. But that is not always the case. Sometimes a license may simply not specify it, providing some sort of unclarity. The two most basic ones, I think, are so fundamental that we often forget about them. Quotation, that's also something we're used to in academia to support our claims. But copyright also, of course, recognizes the need to do this. The specific provision in the InfoSoc directive does say quotation or permits quotation for the purpose of criticism or review, which seems to sort of limit this. And here I will have to recall the fact that this is based on a directive, which means that member states have certain maneuver for implementing this provision. This particular provision has also a very long history in the copyright system, since it goes back to our longest or oldest international treaty from 1886, the Berne Convention. But essentially, the purpose requirement is not always not specified in the member states. So this really becomes, like Eleonora mentioned, it depends. It depends how this has been implemented. So even though this one is optional, we actually see it, I think, in most member states of all of them. Another almost obvious copyright exception is contained in Article 5.1 of the InfoSoc Directive, which is mandatory to implement by member states. So it exists in all of them. That permits temporary copying. And I could really ask, why is there a need for such a copyright exception? But that has to do with the scope of the exclusive right to which this provision is an exception to. So the reproduction right is quite broad, covering temporary uses, such as reproductions or copying in the operating memory of a computer or caching. And this really technical copyright exception is meant to permit these kind of uses, such as when one is running, either or viewing particular types of copyright protected content on the screen. If a license, for example, does not specifically mention this kind of obvious use, the temporary copying exception makes it at least possible to view it on the screen. More relevantly, perhaps, there is a general scientific use exception. It actually has two components for which it's also been criticized. It provides that or permits use for the sole purpose of illustration for teaching or scientific research. That means two things, of course, but on the one hand, it's good for, or it's relevant in the context of teaching, but also in the context of scientific research. The condition is that as long as the source, including the author's name, is indicated, unless there turns out to be impossible, and to the extent justified by the non-commercial purpose to be achieved, which sets an overall cap on the purpose within the scientific research that is carried out or teaching. Now, while it is essential for teaching activities and being able to illustrate to students, for example, many things, or to review and ask them to work with it, this provision has been criticized in that it's unclear what the obligation is for member state, because the formulation for the sole purpose of illustration for teaching or scientific research has been understood or argumented to mean, well, within the context of scientific research, use of works can only be made for the sole purpose of illustration. That's not really how science works necessarily, because the use of works that is carried out in the context of research is much broader than just to illustrate things. That also depends on the discipline, of course, but that has meant in practice that some member states have either refrained from introducing this provision and focused only on illustration for teaching, or that they have included this aspect, illustration and scientific research. So you may use it for the purpose of science, so to say, but only if the idea is to, or the purpose is to illustrate. So in that sense, it's not particularly broad, even though scientific research is not defined as such, but is only limited by non-commercial purpose. So one could say that it has the potential to apply much more widely than in practice. But this is one of the optional copyright exceptions as well. So there are cases where there is no scientific research exception at all. Turning to education for a moment, one of the new provisions that was introduced in 2019 permits cross-border use of for educational purposes. So essentially, online teaching where students need to connect, or there's an online course. The cross-border issue does relate to the principle of territoriality, and this provision essentially localizes the assessment for the purpose of copyright assessment to the country where the teaching is taking place, rather than meaning that depending on where the student may be or how the system is working, having regard to the fact that online systems may very well use servers that may be placed somewhere abroad, or systems or services, instead of having to make a very complicated and at times impossible to determine assessment that will involve very complex jurisdictional issues. The rule is simply that for the purpose of copyright, the cross-border element is essentially removed because acts take place within the member state of operation, so to say. And now jumping back to research, Article 3 of the Copyright Directive, or the ASM Directive, introduced a scientific research exception for the purpose of text and data mining, which has become very essential also in the context of AI, but of course more generally as well. Essentially, the argument was that, well, the temporary copying exception combined with the scientific research exception that not everybody has does provide or create a very uncertain situation for the European scientific sector. So it makes sense to introduce a mandatory, in the sense that it has to be implemented by all member states, provision that will allow text and data mining. So this one is mandatory. Every member state does have it in its own legal system, which does also provide some assurance. And I would like to focus on this provision a little bit more. It is helpful to look into the definition of text and data mining. As lawyers, we are obsessed with definitions. That definition is very broad. Essentially, text and data mining means any automated analytical technique aimed at analyzing text and data in digital form in order to generate information, which includes but is not limited to patterns, trends, and correlations. So the point is really that text and data mining means, well, when you're using an automated analytical technique to analyze information, broadly construed, in order to generate information, whatever that information may be, this will fall under the definition of the text and data mining activity, and also therefore the provision as such. So there is a separate provision as well that I will make a brief reference to in a moment. But essentially, with this broad definition, there is the potential to cover a wide array of uses in many disciplines, statistical analysis, or there are arguments even for the purpose of creating language models, etc., and so on. But essentially, social sciences, natural sciences, computer engineering, and so on. The essence is the analytical techniques needs to be automated, and the purpose is to generate some sort of information, essentially. I should mention, for the sake of completeness here, that because these are very new provision, or this is a new provision, we're still, legal theory or legal scholars are still discussing the exact parameters of this provision. There are no court cases at this time yet, so this is really still subject to interpretation and arguments. But there are a number of things that we can say about this provision. It permits text and data mining by research organizations and cultural heritage institutions, including their employees, for the purpose of scientific research. That term is not defined as such, but the directive does make clear that this should include public-private partnerships, of which we see more, and even financing institutions are requiring this in particular disciplines. And it includes the possibility, or should include the possibility, for a research organization to use the technological tools that a private sector partner may have. And this is an important aspect because, compared to the general scientific research exception, this provision does specify that these kind of activities are to be included. The general scientific research exception does not specify, so that's subject to debate and legal argumentation, notwithstanding the fact that, as I mentioned, that previous provision has not been implemented in every member state, so it may not even exist. So in some cases, this may actually be the only the proper research exception, scientific research exception that exists. Now, the provision also permits these organizations to store or retain copies for the purpose of scientific research. That includes for the purpose of verification of research results, an aspect that is quite essential in science, the ability to ensure that or verify that correct methods have been used or that the data is indeed based on what is claimed in an article and so on. One question or sort of gray area here is in what way this needs to be stored or copies retained, having regard to the fact that the need to be able to verify research results necessarily implies the possibility to access those research results. The provision also applies to all copyright protected content, except computer programs. So literature, photography, film, sound, and so on. The question with regards to computer programs or the exclusion, so to say, of computer programs does raise a certain question about a particular area known as mining software repositories that I will also mention in a moment. So this is essentially what the provision allows. Now, there are a number of catches for this provision to apply. Oh, sorry, I forgot. One of the other aspects is that it's also mandatory to implement or mandatory in contractual relations. So in case, or it's put differently, right holders whose works are used are not able to contract out this provision. That makes the copyright exception very strong in the copyright framework. So essentially, the way this is phrased in the provision is that contractual terms that prevent this kind of use are unenforceable, which means that if an institution or a researcher were to be sued, the court will simply say this term preventing this kind of TDM does not apply such. So there are a number of catches for this provision to apply. The main one or the main requirement is that the organization or researcher needs to have lawful access to the content prior to carrying out the TDM activity. And there's a lot of legal scholarship that is now being created on what this requirement actually means, lawful access. One could say generally that the idea behind the provision or this kind of requirement is to ensure that the user that wants to carry a TDM acts in good faith, that they check, well, I have a subscription, for example, or I've checked content online, it's made available on the basis of a Creative Commons open license, allowing me to access it legally, or the university has a specific license with a category of right holder, for example. Now, that is of course quite basic, but it turns out, of course, that a requirement like this that makes the application of a copyright exception contingent on approaching a right holder, of course, in a very practical and commercial sense, opens up a commercial opportunity for the right holder to say, well, okay, now that you have to reach out to me, I'm interested in either making money on the situation or to otherwise determine what uses can be made or not be made, and to offer a particular set of terms that define what lawful access is. So imagine, for example, that the right holder says, well, I'm not preventing text and data mining. I can try to do that as a commercial aspect, but I know that it's not going to work because this is a mandatory provision in contractual relations. But I can say, for example, the institution is not able to make more than one request per second. So when someone's engaging in data scraping, for example, of legal content or of services that the institution has access to, it immediately raises a very complex legal question whether there's still lawful access when that is taking place, because it essentially could mean a breach of the terms that define lawful access. So it's a bit of a catch-22 situation in some respects. As I mentioned, legal scholarship is working on this provision and exploring it further, what can actually mean. But as mentioned, the basic idea is to ensure that institutions and researchers do the right thing and try to obtain it from legal sources. That's, however, not the only meaning of this provision. A related aspect with this requirement is that it does create a challenge in cross-border situations. So imagine that there is a collaborative project with other institutions, might as well involve private partners as the directive or provision envisages. And now the question transpires, well, does each of these partners, whether academic or private, have to have lawful access in the sense of obtaining a separate subscription? That's not clear. It's been one of the arguments put forward to try to revise this provision, but essentially it does raise concerns both on the sides of the research institutions and on the side of the right holders, of course, because if copyright is territorial and the possibility is to determine what the conditions are for access from different countries, then this would have to mean that, yes, every partner needs to obtain a separate subscription. On the other hand, if you're part of a consortium, well, the ultimate objective is really to carry out text and data mining. That's the scientific part of, or the essence for why everybody is collaborating in a project. So this really is an open question. Now, the provision does not cover sharing the product of text and data mining. This only becomes relevant if somehow the product of text and data mining includes copies or parts of works that are protected by copyright. Otherwise, usually the data that is created following TDM is going to be different. It's not really copies of works as such. Moreover, right holders are allowed to ensure security and integrity of networks and databases where the material is hosted. So that really goes back to partly to the lawful access requirement and the possibility to define, well, either by way of a contract or license or through technological means, the different parameters of how access can take place, which in turn may affect in practice the possibility to make use of this exception. Now, I mentioned computer programs. So these are not covered by Article 3, which raises the question, well, is text and data mining or data mining of software possible? There is a field called mining software repositories. And the short answer is, well, not really. There is a provision in Article 4 that also permits text and data mining for any purpose. And that provision does cover computer programs. However, it is subject to one big essential requirement, which is, or possibility for right holders to what's known as opt out and say, well, we don't want you to use text and we don't want you to text and data mine, which then for commercially oriented developers offers the possibility to just block it in a license. There is another challenge in this respect. MSR focuses not only on software code, but also on other types of resources. Well, what's in software repositories? So it may be communications between the developers during a development project, or it may be various kinds of logs, etc. So content that as such is not protected as a computer program. And that creates a challenge in the European context because the regulation or protection of software understood now very broadly is or falls under different types of regulation from the perspective of a MSR project. So it could be regulated by, there's a software directive. It could be regulated by the InfoSoc directive that regulates textual text like literature and so on, or it could be regulated by a data-based directive as well. So depending on what type of data one is using in an MSR project, it could really activate different kinds of rules, which also does create some complexity in just a simple assessment or question, can I really do it or not? And this takes me now to the second part of my or the last component of my presentation, which is open access and reusing your own research data. So until now, the question really was how do you access and what can you do with the data that you access? Now, a very separate question, not completely different though, is how or can you reuse your own research data? The answer seems obvious, of course. The idea here is to view the researcher as the creator of copyright content, not as a user as such. As mentioned, researchers, of course, produce a lot of information. A lot of it is going to be copyright protected. Eleonora already hinted that the question of ownership is really separate. It may be affected by employment agreement at institutions, sometimes not. That really is a national question, as rules vary, but the fact remains that a lot of information that is protected is produced. And these kind of questions come up in a number of contexts. One is, of course, when you publish your research results on publication agreements, for example, with various kinds of scientific publishers. Often you provide a license, or Eleonora spoke about licensing and transfers. There's another term that does appear when discussing licenses also, which is assignment of rights. How one's used that is really a national matter, but there's basically two ways of doing it, as Eleonora hinted. Either a publisher requests a license, which can be exclusive in that you only contract with us, or non-exclusive, and the publisher receives the necessary rights from the researcher to do what they need to do, for example, publish. Or there can be an assignment of rights. I call it here, like Eleonora called it, transfer. It really doesn't matter. The point is the legal effect, which is that the rights sort of cease to exist with the researcher and become the publishers. There are publishers that use these kind of things as well. It really depends on the type of publisher and their rights management strategy. But depending on which one it is, that will, of course, raise the question of what you're allowed to do with it once your article is published, because either the rights that you previously had to your research results or the publication will belong to the publisher, or they may actually belong to you, and the right holder, the publisher, simply has a license to carry out their works. We normally see this in open access journals where they want to make available open access the research results or a publication, but they also often just require you as a right holder to provide the necessary rights for them to be able to complete that kind of task. There's also on some markets so-called OA deals or transformative agreements, or there is financing from financing institutions that allow researchers to request that an article, for example, be published open access, which then requires of the researcher to select what type of open access they want. Usually Creative Commons licenses are used for this, and from what I've seen, the choice is either broad use and just it's necessary to provide or attribute the source to the researcher, or there's also a condition for non-commercial use. But not every journal, of course, has this kind of option. This is really a changing market that a lot is it's very fluid at this time. So it's not really a given either. But what is offered really depends on the actor, every type of actor, or even a publisher, or even journal, since they just use their own different strategies. Another context where this may come up is so-called technology transfer agreements in public-private partnerships, which are often types of agreements that are concluded in order to transfer knowledge between academic institutions and industry partners. These are normally IP transfer agreements, or what can be done or can be commercialized, what stays within the institution, and so on. When these kind of agreements are entered into, that normally activates or catches the interest of lawyers that are working at an institution to ensure that the agreements are as good as possible, having regard to what the institution also wants and what what the public or private partner sort of contributes with and what they're entitled to. Now, reusing your own data, I sort of mentioned this already before, but where do you do that? There's first a possibility to do it. Well, is there an agreement that affects it? But there's also the question of reusing what you've created and placing it somewhere. And many institutions have their own repositories. There are also many repositories that are openly accessible, like ResearchGate, for example, or academia or SSRN, depending on the discipline. There are also discipline-specific repositories. So if we think of data as not only a publication or an article, but also actual raw data that is used for quantitative analysis, for example, there are disciplines that try to maintain repositories where this kind of information can be published, for example. Ultimately, it comes down to the policies, actual rules that apply. So that's really a national matter. Institutions may have policies that determine or actual rules in contracts or otherwise determine that concern ownership and therefore what can and cannot be done with the publications or the data. They may require that data be published open access, the research results. Funders also may require that increasingly more, and so on. So there's no easy answer here, of course, but there are importantly challenges, because if there are, so to say, blocks, or if there are agreements that limit that kind of use, of course, the question is how can one realize open access, which is also becoming increasingly more important. So I thought I could mention, sort of approaching now the end of my presentation, but I thought I could mention a certain type of mechanism that exists in a number of member states. So this is not EU law as such. It's called the secondary publication right, that essentially makes it possible to make available already published research through alternative outlets, like a public repository. It's said to support green open access. So that's basically self-archiving. Indirectly makes it possible to reach a much broader spectrum of audiences. For example, researchers that may not have the possibility to contract access or subscribe to particular resources or services. As a legal mechanism, it's also intended to strike a balance between various interests and to try to manage this aspect of realizing open access and the availability of publicly financed research and so on. And well, I am running a little bit out of time. And like I mentioned, this is not really a European type of right now. A number of countries do have this. It's Germany, Netherlands, Austria, France, Belgium, and most recently Bulgaria, that permit this kind of use and also make it contingent on, well, for example, how much public funding is behind a particular project. They make they impose certain conditions for the type of scientific output that is covered. So not everything that is created, but for example, a scientific article in a journal that is published once or twice a year, what kind of version of it applies to. So most of the mechanism that exists in the member states concern what's known as AAM. So that's author accepted manuscript. That's basically the Word file that's been accepted by the publisher, but not the final version of record. Some member states do not have an actual limitation as to that. There are in all of the member states essentially a form of embargo period. Well, not in Bulgaria, but for example, Germany and Austria make this right apply after 1 year of publication. The Netherlands states merely after a reasonable period. Bulgaria has no embargo period, and so on. So the way in which the balance is struck in these countries does depend on the choices that are made. There is a study that I had the opportunity to work on before, where we did propose the introduction of such a right. So it really does remain to be seen whether it will be adopted by the European legislator in the coming time or not. Of course, it's specifically aimed at the research sector, but this is also a sector in transition. So going towards the end of my presentation, I thought I could end with a sort of checklist and do's and don'ts. Of course, I realize that researchers aren't really lawyers or the copyright lawyers that are supposed to have answers to all these questions. It really is licensing and copyright exceptions really are very complicated, and there's a lot of judgments from the courts that go in all possible different directions. But as a sort of rule of thumb, generally, one can think of the whole thing as a sort of distribution chain. Eleonora also mentioned that, well, even if the creator has the rights initially, possibly who the actual right holder is will depend on a number of factors. It can be a license or a transfer. It can be an employment situation where the employer may have the rights and so on. So I just make a difference here between creator and right holder. There is some sort of bond between these. And of course, going forward towards the end user that is interested in using copyright protected content, everything always starts with rights management strategies. So there are rights. How will these rights be made use of? To what extent? For what kind of content? What other conditions may be attached to it? That is translated into concrete licensing arrangements often that we see, and they may overlap with copyright exceptions. They may try to contract them out. We have seen that kind of provisions as well. So that these two contractual arrangements, copyright exceptions, essentially determine what the user is allowed or not allowed to do. When the end user receives the content and starts to use them, of course, copyright exceptions can determine what they are allowed to do in terms of, well, I call it transformative use, right? So one is access, which one could sort of think of as a consumptive type of use. You access to read and to consume, and then transformative, the access because you want to do something with that information or the actual expression, say text and data mine, or you want to analyze it and produce something out of it further, which sort of goes back to the first stage or closes the circle, because the end user can, in that sense, also become a creator or a right holder, and sort of the circle continues in this respect. So in terms of a checklist, one can, of course, start with, is the object protected by copyright law? Or does the use that you want to make fall under the rights conferred by copyright? Normally, the answer will be yes. The reason for that is that a lot of things are protected by copyright, all types of content, one could easily say. And the use, the rights are very broad and do go as far as temporary copying, for example. It is only when one is dealing with information that or content that is in the public domain, so to which copyright has lapsed, that one can with some certainty say, well, I can't actually use this; it's not protected. Now there are, of course, exception to this rule of thumb, so to say. There may be information that is part of cultural heritage, and there may be national legislation that affects what use can be made and in what context of it as well. There is also the moral rights that Eleonora mentioned. Once that is established, who is the right holder? So the license can only come from the right type of actor, the actor that is authorized to actually give you the type of permission that you need. There might be already a license through your library, for example, or other resource that may cover the use. If there is, it's often made possible through some sort of centralized system at an institution. But the most important question is actually question 5, because even if there's a license, there is still a possibility that the use may be covered by a copyright exception. And that really does raise the most difficult question, which is, does a copyright exception supersede a copyright license? So if if 3 and 4 overlap, does 4 supersede 3? And I'm afraid that as a general rule or answer, I think one can fairly say we don't really know. Eleonora implied that, well, as is often the case in copyright, it depends. That is, of course, the right approach. But the issue that we're facing today is that there are provisions that, as in the case of the text and data mining exception, where the framework explicitly said this is mandatory in contractual relations, cannot be contracted out. So text and data mining does supersede any license that tries to do something else. For the other ones, it's not provided from a European perspective. That means it's been understood as it's open to the member states. Now, looking at copyright history, we don't always find an answer to that question in national legislation either. That is because the way copyright is transacted today is very different from how things worked, say, 100 years ago or 50 years ago. It's no longer acquiring a bunch of books, for example, or material that you have physically in your hand. It's often services that are governed by different types of terms and conditions. And these interact a lot more with the copyright exceptions that may exist. So it's simply sometimes a question that cannot always be answered, I'm afraid, that may perhaps tilt the balance towards either trying to be more cautious or risk averse, or on the other hand, actually trying to use the freedoms that may be available broadly, having regard to the purpose that a provision may actually serve. So do's and don'ts. I have the opportunity to speak to researchers often, and one thing that transpires is that when they see copyright terms and conditions, of course, they run away. That's completely understandable because, well, copyright researchers are not copyright lawyers. But I think that it's important to not be afraid of copyright. Yes, it can be very complex. Bargaining that necessarily does take place is just a form of business for many categories of right holders. They do not necessarily, the contracts or licenses often necessarily reflect the full legal rights that may follow from copyright exceptions. Is, like I say, is just business. We see this in any other copyright sector as such. There are rules that determine what it may be possible, what may not be possible. The approach really needs to be to try to openly approach it. Another do's and don'ts, do not assume that all use is prohibited. For the same reason, researchers may be afraid of copyright. They see a terms and conditions, some sort of transfer or license, and worldwide and royalty free, and all of it is complicated. Probably you're not allowed to use it. Actually, that's not correct. That really depends, of course. But there are publishers or journals that, as I mentioned, they just want a license from you in order to be able to do what they want to do. There are indeed those. So what that means is that when there has not been a transfer of rights or assignment of rights to them, you're still the right holder. You can do whatever you want with it. But of course, this is really where one needs to look at the terms and conditions that do it. But it's important to not assume that only because there's some sort of terms and conditions that is going to be prohibited. There are journals where that is actually described in a user-friendly way, or that you may do certain things, etc. So it's really about trying to comprehend or reading the agreement. At the end of the day, might just be as simple as sending an email to the publisher or the journal. The more formal stuff, of course. If you want to use others' material, important to check under what conditions that material was made available and whether there's any exception that may authorize you to do what it is that you want to do with it beyond just accessing. If you want to share your own research data, same thing here. Check really if there are any terms that affect your use of your own material that you have created, or if there's a policy at the institution, or even if there's an SPR that may cover the use, which is, of course, as I mentioned, limited to particular member states. Perhaps the most important one is do consult your mainly it is the librarian. Librarians are your best allies when it comes to license literacy. They are the people that have to deal with these things or licenses to ensure that the library is able to do its function, including provide access to various services. Of course, copyright is a very complex area. They are not necessarily copyright lawyers as such. Nevertheless, often they are the first source to reach out in copyright questions, and if they don't know, they might or should know whom to reach out to. So just as a final reflection, I thought I could finish with a thought that of course, and I guess this has become clear towards the end of my presentation. Copyright. There's a number of choices one can make in copyright. Not everything is clear. There are gray areas in this field of law. As researchers, your role is not just to comply with the framework, but I think also to ask the right questions and insist on receiving answers. That may take some time and may require some risk taking as well. But ultimately, if the framework is designed with you in mind as well, then you are an actor or stakeholder in the copyright system that should be able to know exactly what they're allowed to do. So, for example, if you're forced to publish open access because financing institution requires that kind of thing, of course, the primary question is, so how can you realize that? Are there tools nationally that would allow you to do that? All right. Thank you so much.
Thank you very much, Kacper, for your valuable insights and information shared. Thank you all for your comments shared in the chat and questions. We can go with the first question. How many countries have not introduced the InfoSoc research exception?
Yeah, should I take it?
Yes, please.
Actually, I don't have a full list of that. There are a number of member states that have not introduced it, and as I mentioned, there's also those that have preserved this in one form or another narrow reading of the provision, that it can only be carried out in a for example, scientific paper or scientific context for the purpose of criticism or review. So it's either blending, depending on the tradition, or just uses a narrow type of reading of this provision, or for the purpose of illustration, which I would generally perceive as being much narrower than what the European legislator may have intended as such. But what the European legislator does in the InfoSoc directive and what's happening within the member states are two very different things, really, because it's a matter of national policy and approach. I think that's where the discussion may also be concentrated.
Thank you. Can a teacher professor claim that he or she uses a copyright work for teaching purposes plus for non-commercial purpose if her students have to pay for a scholarship? Or in other words, do we have an indirect commercial use? What means that the exception does not apply here?
Yeah, I can take it as well. Well, I think this is a great question because it's also a question that legal scholarship is pondering about. Education or teaching is as such, I mean, an activity that is quite clear, even if the student has to pay. I mean, even at universities, many member states require that students pay tuition fees. So one could even say that there's a commercial element when you study at a public university, for example. So I think that this right now turns onto national interpretation, how that is to be perceived. I don't want to say immediately that activates so to say, activates commercial use. But for sure, it can be understood in that way as well. So maybe there is a suggestion that what might have to be the determinant factor is the type of institution that carries out the teaching. So if there is a company, for example, in the private sector that is in the teaching sector as such, and is not carrying out a particular task for the benefit of an institution, that could be a commercial use compared to, say, a public university that uses tools from private companies in order to carry out teaching, for example, or where students simply have to pay to attend the class. I mean, that's the line is really hard to draw. I probably see this as being a national matter as such. Ideally, it should not matter when it is a public institution where every citizen or member of society is able to sort of sign up for as such, even though it may have to be paid.
Thank you very much. Is there any other question at this point? You can also raise your hand. Okay, just to inform you that all the presentations used will be forwarded to you. Also, if there is any question in the future, feel free to reach out. Thank you all for attending today's session. Your participation and insights were truly, truly valuable. We appreciate your time and look forward to see you in future sessions. Thank you very much. Have a great day ahead.